Mr. Bowman, it strikes me that how much your opinion has changed in just a few years. It pointed out that in your 2019 book entitled High Crimes and Misdemeanors, A History of Impeachment for the Age of Trump, you have this passage. No Congress since that time, referring to the impeachment of Belknap, the cabinet person that Grant had dismissed before his impeachment. But you say, no Congress since that time has either moved fast enough or thought it worthwhile to actually impeach a subordinate executive branch official. Nonetheless, the latent power to do so remains important. And here's the key sentence. Not only is it useful as a signal of legislative displeasure with administration personnel and policy, but the undoubted authority of Congress to impeach subordinate officials carries with it the associated powers of the House to investigate potentially impeachable conduct and of the Senate to try the allegations in articles of impeachment. Now, frankly, sir, I agree with you more today and not then. That is to say, I don't think pure policy differences is the basis for an impeachment. Neither is that what's happening here. It is exceedingly apt for that reason that the majority witnesses are 3 state attorneys general. Gentlemen, I look forward to joining you in 2025. But let me point this out. A lot of people would say, well, American people are interested in hearing something about a legal case. I think they might be. Last June, 2 of your colleagues in Texas and in Louisiana had sued Secretary Mayorkas, saying that guidelines that he issued to his department blatantly violated commands of Congress in statute to detain any criminal who had committed certain crimes and was released from state custody. Were required, the Attorney General then, the Secretary of Homeland Security later by amendment, required to detain such persons until they were deported. And persons subject to a permanent order, a final order of deportation, required to be detained. Contrary to that order, Secretary Mayorkas dismantled the detainer process completely. He said that that was going to be subject to discretion, only in cases where the department or he deems it to imperil our national security or security from additional crime would it be done. Attorneys General sued, and here's what the Supreme Court said. You don't have standing. We can't hear from you. We can't settle this. Here's what Alito said in dissent. The Congress, to put the point simply, Congress enacted a law that requires the apprehension and detention of certain illegal aliens whose release it thought would endanger public safety. The Secretary of DHS does not agree with that categorical requirement. He prefers a more flexible policy. And the court's answer today is that the executive's policy choice prevails unless Congress, by withholding funds, refusing to confirm presidential nominees, threatening impeachment and removal, etc., can win a test of strength. In other words, Alito in defense went on and said, I don't think this is a wise decision for us to make, but that is the decision the majority made. That if you want the law to be followed, you're going to have to impeach somebody. You're going to have to, as Justice Alito said, the Congress is going to have to go to war with the executive. Mr. Knudsen, what about that? Isn't that right? Isn't that what the Congress is put to decide whether to do our duty? As the Supreme Court has said, we can't do it. It's up to the Congress. And you guys have tried to do it. You've succeeded in other areas. You're continuing to sue, and you're succeeding. Florida has enjoined some practices. I think the Supreme Court just granted an emergency relief from the DHS cutting Texas border barrier. What about that, Mr. Knudsen? I didn't leave you a lot of time, but I'm sure you can add more wisdom in 30 seconds than I did into it.
I'll be brief, Congressman. Thank you for the question. Yes, I absolutely agree not only with Justice Alito's dissent, but I would point out also in that case that the majority also pointed out, to your point, that Congress possesses an array of tools to analyze and influence those policies, and those are political checks for the political process. That's exactly what you're dealing with here. You folks have got an executive versus legislative branch war here.
So much of this, Mr. Chairman, isn't about even policy discretion that's granted to the administration. It is about square violations of law. And they cannot be remedied in court. They will either be dealt with by this Congress to vindicate the rule of law, or we will surrender rule of law to a rule of man. I yield.
The gentleman yields. I now recognize